Hello, and welcome to another episode of Yee's Law Journal, where we break down the latest legal developments and their implications for businesses in a fast-paced, practical way. I'm Josh, your host and a partner at Zhonglun Law Firm, one of the top international law firms headquartered in China. Today I'm thrilled to be joined by Alice, my co-host. Alice, how's it going?
Hey Josh, it's going great. I'm really excited about what we're covering today. This is a big one for both the tech and legal communities, right?
Absolutely. We're diving into a topic that's on everyone's radar, generative AI and its intersection with copyright law, specifically how it all relates to text and data mining exceptions, or TDM. It's a complex area, but we'll break it down into bite-sized pieces so that everyone can follow along. Let's jump right in. So before we dive into the details, let's start by explaining the basics for anyone who might not be familiar. Alice, do you want to take this one?
Sure, at its core, TDM, or text and data mining, is all about using automated techniques to analyze large sets of data. This helps systems like generative AI spot patterns, trends, and relationships in the data.
Exactly. Generative AI in particular relies heavily on TDM to learn from existing data, whether it's text, images, or even databases, to create new content. But here's the thing. A lot of that data is copyrighted. So the big question becomes, how can AI systems use this data without crossing legal lines?
And that's where things get tricky, because even though AI needs this data to function, the copyright laws in place could limit how AI systems can use it. But that's where TDM exceptions come into play, offering a bit of breathing room for AI developers.
Right, so let's talk about that breathing room and how these exceptions work in practice. Alright, so the key to making all this work is understanding the EU's AI Act and how it interacts with the Copyright Directive 2019-790. The good news is that there are two important TDM exceptions built into the law.
Exactly. The first one allows TDM for scientific research, pretty straightforward, and mainly for universities and research institutions. But what we really care about here is the second one, which allows for general use, including by for-profit companies.
Right, so in theory, this means that a company developing an AI system can mine data from copyrighted works without always needing permission. But, and this is a big but, there are conditions to keep in mind.
Yes, there's always a catch. And that catch is the opt-out mechanism, which gives rights holders the power to say, not so fast, let's break down how that works.
So here's the deal. Rights holders like authors, publishers, or creators can essentially put up a digital do not disturb sign on their content. They do this by attaching a machine-readable notice to their work that says, you can't use this for TDM.
And it's actually pretty simple. They don't need to install any technical barriers or complicated software. Just adding this notice is enough to block AI systems from using their data, legally speaking.
Exactly. And this notice can also be part of a contract, so if you're an AI developer, you can't just assume you can mine any data you find. You have to make sure that the content you're using isn't opted out.
That's a huge point because it puts the responsibility on AI developers to check for these opt-out declarations, whether they're visible in the code of a website or baked into a contract. But Josh, it's not just about getting access to the data, right?
Nope, not at all. There's more to it. Even after you've mined the data, there's another key rule: data retention.
Right. So once you've used the data for TDM, you can't just hold on to it forever, can you?
Exactly. Once the TDM process is over, you have to discard the data unless you're still using it for active TDM purposes. Think of it like borrowing a book from the library. You can't keep it forever just because you borrowed it once.
And that's where AI developers have to be careful. Even though they might have legally mined the data, they can't just stash it away for future use. It's a constant balancing act, ensuring you follow the legal requirements while pushing forward with the technology.
Yeah, and speaking of balancing acts, let's talk about the big question on everyone's mind. Can AI developers actually use these exceptions for training their systems?
Good question. So, Josh, in practice, can generative AI developers actually rely on TDM exceptions to train their models?
Yes, they can, and this is important, only if they meet three key conditions. 1. Legitimate access AI developers need to ensure they have lawful access to the data.
2. No opt-out. They need to make sure the rights holders haven't opted out.
3. Limited retention. They can only keep the data for as long as they need it for TDM.
It's a pretty specific framework, right? You've got to check all those boxes or you're risking a potential copyright violation.
Absolutely. It's a great framework for getting access to the data you need, but developers can't get complacent. There's a lot at stake here, and it's not just about following the rules during mining. It's also about what happens after the mining is done.
Speaking of what happens after, there's another layer to this. Even if the data mining process is legal, there's still a question around AI outputs, right?
Yes, and this is where things get really interesting. Let's say your AI system generates new content that looks a little too much like the original material it was trained on. That could open the door to claims that your output is a derivative work, which would be protected under copyright law.
Exactly. But here's the tricky part. What counts as a derivative work when it comes to AI-generated content? That's something courts haven't fully figured out yet.
Right, so even though the TDM exceptions give developers some freedom to use large datasets, they still need to be very careful about how the AI's output might resemble the original content. We're definitely in a legal gray area here.
So before we wrap up, Josh, let's give our listeners a quick summary of the main takeaways if they're working on AI projects.
Sure thing. If you're an AI developer, here are the key points to keep in mind. 1. Get legitimate access to the data. Don't cut corners. 2. Check for opt-out declarations. Make sure the data isn't restricted. 3. Limit how long you keep the data. Follow the legal guidelines for retention. 4. Keep a close eye on how courts handle AI-generated content in the future, especially around the issue of derivative works.
Yeah, because the law is still catching up to the technology, and staying ahead of these changes is crucial.
Absolutely. It's all about staying compliant while continuing to innovate. And with that, we've covered quite a lot. Thanks for joining us today on Yee's Law Journal.
If you enjoyed today's episode, don't forget to subscribe and leave us a review. We'll be back with more discussions on the intersection of law and technology. Stay informed and we'll catch you next time.
Thanks for listening and see you on the next episode of Yee's Law Journal.